Hi, good afternoon, everyone, and a very warm welcome to our Logical Talk number 12.
Hi, good afternoon.
Good afternoon, Adarsh sir. All right, so we have all our guests already on with us. Before I start with the discussions, I just want to share one important milestone with all of you. Today, we complete our 1 year of doing these series of webinars, which we now call the Logical Talk. It's we've completed this entire 1 year with no break, and today we have we would have addressed more than 3,000 audience from different verticals, and during this process we have spoken about varied subjects, starting from, where the first one we started was the higher pension scheme. We moved on to, we spoke about DPDP Act. We spoke about codes on wages. We, discussed about dematerialization of shares and varied topics. And today we are back here with gratuity. We touched on in between. We touched upon RBI circular also. We touched upon you know um, uh, uh, you know sorry, I forgot. That's the variety. And also the good thing is that we've got a tremendous support in this last 1 year from the industry also, because it would have not been possible for us to continue this series if we didn't have the experts with us who were sharing their real practical experiences, who were talking about the real scenarios which people were sharing, have faced. And that's something which has really led us to continue, and rather this motivates us also, because today I'm seeing we continue getting a lot of requests and a lot of queries from you all about some new topics which you want us to talk about, and cover. And when we approach the industry, we have also been fortunate that people are willing to, also share their expertise, because I think this has become a platform where we are all sharing the, ideas and knowledge. And all thanks to you all who have really been very, very uh, kind enough to all of us, and that we have continued this journey. And we hope after completion of this 1 year, we would start innovating more. Uh, we would, bring some more flavor to these things. Maybe in the next few quarters, you would see some of those coming. On the ground level, also you would start seeing some of those variations which we would start implementing. And please continue providing us all your support, which you have always been kind enough with us. And I specifically want to mention my team, which has been working at the back end to really make it happen month by month. They have a plan ready for the next whole quarter, what all subjects they want to cover. I have my colleague Trishul. I don't know, Trishul, if you are here, you can switch on your camera. My colleague Ankita, Akshit, they're the ones who are the brains behind this entire initiative, and who are really ensure that we continue this journey. Thank you so much. And from our IT technology support and marketing teams, my colleague Kuldeep, Mukesh, Rajat, they have all ensuring that whatever we are deciding, the platform is working smoothly and you are being informed. Thank you so much for your support. And specifically on this day, I want to also say thanks to Anurag. Was with us for our first webinar, and I would say it was not just partly. I'm saying it's a lot of his initiative, which we continued. And Anurag, thank you for being back on the 12th edition also. And Adarsh, thank you so much for coming back again. And we look forward to have you again on this show, on our discussion again.
Thanks.
Uh,
Thanks.
I'll just quickly touch on this our customary slide. You all are aware, Lawrbit offers SaaS-based risk and regulatory compliance management solutions for enterprises across globe. Our software comes integrated with the regulatory intelligence for spectrum of laws. I would say any law which is applicable on your business in any jurisdiction, we would be able to support you. Today we have clients across the globe. We're serving around 250 plus entities across globe, in 10,000 plus users, 1,500 plus locations, and our team of lawyers, company secretaries who are working at the back end for ensuring you get all the correct regulatory intelligence and updations on the real-time basis. And with the continued support from all of you, we have been fortunate enough to ensure that we're still maintaining 100% enterprise client retention. None of our clients have had any bad experiences. I'm just, experience which could lead them to leave us. And thank you so much for this. I would now want to introduce to you all to our speakers of the day. I'll start with Arvind. I think, Arvind, there's a spelling error in your name. Apologies for that. Um, Arvind, Arvind is a is a very good friend, and I would say somebody who has always been challenging us. Who has My voice is not audible. Sumanta is saying, "Is it?" Anurag, can you hear us? Can
Yeah,
you
yeah,
hear me? Okay, great.
yeah. We can.
Sumant,
Yeah,
I think
yeah,
you,
yeah.
Sumant. Okay, Sumant, I think you'll have to check your speakers. Um, Arvind is a legal professional. He is currently a general counsel of Answer. In his prior 15 years of experience, Arvind has worked with clients like companies like Capital One. That's where he started his journey, professional career from, to Target, to Accenture. He was the legal counsel for Musk, GSC in handling their global operations, to Northern Trust, and now in Answer, which has global operations. Arvind is responsible for handling this, and in fact, not just the global operation from a general GC standpoint. He is very actively involved in the business operations as well, in ensuring the business flourishes, and he's actively participating in the strategies and the business expansions as well. Arvind, thank you so much for accepting our invite. I've been trying to convince Arvind to be our speaker for almost like 6-8 months, and finally, I think Arvind has agreed. Thank you, Arvind, and welcome here. Adarsh, sir, I can't spell his. I can't still say his full name. It'll be always Adarsh sir. Adarsh sir is the founder of Nidhi Niyojan. He is, I would say, one of the few voices in India who have very good solid understanding and expertise on on HR laws, on actual gratuity and social benefits, not just in India, globally as well. He comes with 36 plus years experience. He has worked extensively in Maruti and HCL, where he was responsible for his piece globally. He's worked with law firms, insurance companies, and all, not just India, but globally as well. So his understanding is solid on this subject. And I would say, let's utilize his expertise today. If you have any questions, please feel free to ask Adashar. Uh, Adashar, thank you so much for being here again. And Anurag, uh, Anurag comes with the with industry plus consulting experience. He was he's worked with the big fours, and today he runs his consulting firm called By the Books, where they are which offers a variety of services from a tax to social security, immigration issues, PF, or your you have, if you're creating trusts, and he has worked with some of the biggest names in India, and supported them globally as well. Anurag, thank you so much for being here. Uh,
Thanks.
and before I hand it over to them, just for a quick disclaimer, these discussions, these platforms are meant for idea sharing, and none of the opinion which is coming from the speakers should be taken as their, what an experience, an advisory from their firm perspective. It's an idea sharing platform where we will try and address the queries which we have received on this particular subject. So what we are going to cover, so we'll start with a quick background about the Gratuity Act 1972, which we are all aware. So we'll move faster. We'll quickly move on to the recent change which we all are experiencing about Karnataka Compulsory Gratuity Insurance Rules 2024. Uh, and we will also touch briefly on the new labor code and impact on gratuity payment to employees. Now, this is where it'll start getting very technical and very interesting as well, because that's how I've seen this discussion, because we've been up and from both gratuity payment to employees, the tax impact on employees and tax implies impact on the employees. That's going to be very interesting discussion. Key takeaways, and a lot of queries we have received on this subject, and we have already published one FAQs also on our portal. But despite that, also we have been receiving a lot of queries onto the subject. We will try and address with some live examples as well. So with this, I'll hand it. I'll invite Anurag to take the discussion forward.
Thanks, Jayant, and heartiest congratulations on achieving this milestone. But I think there are still miles and miles to go. So
Yes.
with that, we will start with our today's topic for discussion, and let's have a quick background as to what the Payment of Gratuity Act is all about, and then of course we will be coming on to the Karnataka and other aspects as well. See, gratuity, if we look at this law, it came in 1972. So before that, what used to happen was the states used to implement their own gratuity norms. So I remember West Bengal used to have their own gratuity rules. And that was the precursor for the government to take a step and say, why not form a central legislation basis which the states will be basically forming their own set of rules. And that is how the entire Gratuity Act came into picture. And the purpose of this legislation is to provide a uniform pattern of the payment of gratuity to the employees for the services which has been rendered by them. And so this act is applicable to factories, mines, oil fields, plantation, ports, railway companies. So these category of establishment, they are mandatorily covered as per the Payment of Gratuity Act. But then if we talk about other set of companies and shops, in that case, they would be covered under the Gratuity Act, provided the number of their employees is 10 or more. There are certain other notified establishments which government keeps on notifying from time to time, which can also form part of that coverage. If we talk more so from the employee eligibility side, interestingly, if we look at the other labor legislations, like if we take example of PF, they have prescribed a salary cap of 15,000. If we look at ESI, they have prescribed a salary cap of 21,000. But if you look at gratuity, they haven't prescribed any salary cap for the same. They're saying any person other than an apprentice who is employed and who is providing services to a covered establishment will be an eligible employee. In terms of when does a gratuity become entitled, again, an interesting aspect here is that, like in the case of if we see ESI and PF, wherein there is both the employer and employee contribution, there's nothing per se which is recovered from the employee. Rather, the employee gets entitled to a gratuity payment once he has rendered a continuous service period of 5 years, and it is payable to such an employee on account of certain events like superannuation, retirement, resignation. Of course, on death or disablement, this 5 years condition is not applicable. Not many people are aware that 5 year conditions is not applicable in death or disablement cases wherein the amount is being paid to the nominee or the legal heir. Uh, if we talk about the continuous period of 5 years, again, yes, the benchmark is 5 years, but if we look into the fine print, the law has defined what is termed as a continuous service. And if we look deeper, what they're saying is that a period, even for a part of the period, and they prescribe it is 190 days for establishments who are having work days less than 6 days a week. it is 190 days. For establishments, any other establishments, it is 240 days. So for them, even if for a part of the year, which is exceeding the 190 days or more, the employees continued, it will be construed as a 1 year. So even if the employee ends up completing 4 years and 190 days, or 4 years or 240 days, he or she should be eligible to get that gratuity amount. If we talk about who are the employees which are not forming part of this particular beneficial legislation, these are people who are apprentices. Of course, apprentices is something which is governed by a separate set of legislation. Also, the people who are holding a civil post under the central and state government, because all the central and state government employees are covered by the respective gratuity legislation. How is gratuity calculated? There's a prescribed methodology. There's a formula which says 15 days last drawn wages for every completed year of service or part thereof in excess of 6 months is how the gratuity calculation is done. So before we move on to the next slide, Adarsh sir, Arvind, do we have any specific comments on this background? Any inputs that you would like to share, or any practical experience that you would like to share here?
One from my side, Anurag. So what happened that is as early as last week, we got to know that Secretary Ministry of Labor, they
Mm,
are meeting corporates, and they wanted some inputs that what should be a better social security implementation way, and what challenges corporates are usually facing as far as the three acts are concerned. So one of the
mm,
suggestions what we have put in before the secretary was that, see, there is an ambiguity in the definition of wages. So PF
mm,
says that the upper threshold is 15,000, ESI says 21,000, gratuity doesn't has any, but in the new Social Security Code, which is going to happen, they are
mm,
contemplating to have some wage limit also defined there. So we said that whatsoever you define there, there should be a uniformity, so
mm,
that there doesn't remain any confusion amongst the industry that just related to the wages, that what is the
mm.
wages which are applicable and which is to be recovered. This is
Yeah.
more important because just for the benefit of all, see, once the social security code comes, in that case this ECR business will go away.
Mm,
We filed that electronic challans, we filed for PF. There will be government is contemplating to introduce a composite and a common form for all social security legislations, what we will be covering in the subsequent slides. So there will be one composite challan which employers need to file, and then this goes to a kitty, central kitty, and from central kitty this will get distributed amongst the states as per the prevailing law of the particular state. So this is going to happen. Now, this composite challan is quite a ticklish business. Need to understand how it will be structured, how and how it will be different from the current ECR what we are filing.
mm.
So from that perspective, our proposal was that wheresoever we can have a uniform definition of wages, it should be implemented. So that was one of the suggestions given from our side.
Okay. And for the benefit of the larger audience, because we have used the word wages, and as we all know, under the respective labor legislation, as per the present regimes, the definition of the wages is as per the respective legislation. So if we talk about wages under the PF Act, the definition would be different vis-a-vis what definition has been prescribed under the Payment of Bonus Act. Even under the Payment of Gratuity Act, the wages means primarily basic plus DNS allowance. So whenever companies are calculating, or whenever payroll and HR guys are doing that calculation, we have to keep in mind how wages has been defined. And again, it is a last drawn wages which needs to be considered at present. So this is some important key aspect that one needs to consider when they are doing those relevant calculations. Now, if we move to the subsequent
I will,
slide.
Anurag,
I will also contribute. Yeah.
Mhm.
sorry, I had one point which is more
Yeah.
of a practical problem which I have identified, and people have asked me,
Mm,
is that we have many of the entities which keep changing their employment, and these are related entities. They keep changing the employment of their employees from one entity to another
mm,
for various reasons. Now, all these people, the Act doesn't cover that whether they would be eligible for gratuity or not when they change from one entity to another. And that could be a question in the employee's mind as well as the HR personnel mind, that how to treat that continuity of service and how to calculate that 5 years term for somebody to be eligible. And this is something which is not covered in the enactment, but this is generally covered in the understanding or the settlement or the arrangement which the entities have while they are actually passing these employees from one payroll to another. And more often than not, they actually like to give the continuity, and based on that, these people get that. So that's something which is not covered in the enactment, but definitely covered through the agreements which the parties enter in these cases.
Absolutely, absolutely, Arvind. You have touched a very, very good point around this, and this is, in fact, we have received a lot of questions around this. We are covering this particular aspect in our FAQs as well. But just to highlight, there are jurisprudences under the Payment of Gratuity Act which have dealt with such kind of issues. And interestingly, it not only covers issue wherein employees are being transferred from one entity to another within the I can say territorial waters of India, but there are cases wherein people have been transferred from Indian entity to a holding entity which might be located outside India, and the courts have contemplated how the Payment of Gratuity Act would be covering those set of employees as well. One good question that I'm seeing coming up is whether gratuity payment should form part of CTC or is it over and above CTC. I would say again, law doesn't prescribe anything. There are different practices. Again, as per the policy of the company, we have seen cases wherein companies make it a part of a CTC. We have seen cases wherein it is over and above CTC. But for former companies, I would say exercise a lot of caution, because once you make it a part of a CTC and you structure it accordingly and say, okay, 4.81% of your basic will be dedicated towards gratuity. Tomorrow down the line, the employees can come up and say, look, fine, you recovered this amount from my CTC. Because I wasn't able to complete a 5 year service, why am I not getting this amount back? Because you assured me that it will be forming part of my pay package. So this is one caution point that I normally advise my clients, and I always say that uh, uh, either make it over and above the CTC, that is the safest approach. But if you're making it, be ready to answer those questions or make suitable policies around such kind of cases as well.
Correct.
Yeah.
And for the employees' benefit, see, whenever any employee changes the employment, so they should definitely, if someone is having someone is a lateral hire, so they should definitely negotiate with a new employer. That type of benefit should be passed on to them, whatsoever the past service benefit what they are put in their previous employer. So that is again a negotiation point for employees also.
Yeah. So quickly coming on to the Karnataka Compulsory Gratuity Insurance Rules 2024. So it came in January 10, 2024. And to put things in picture, it is not a sort of a surprise thing. If you look at the Payment of Gratuity Act, the Section 4A of the Payment of Gratuity Act has got a clause wherein they provide for the compulsory insurance. They say that as and when notified by the appropriate government, the organization will have to take a compulsory insurance, and there will be other sort of like requirements which would be applicable as per that particular section. And it is this section basis which the state of Karnataka came with these set of rules. Of course, we will dwell on what these rules are all about, but before that, what exactly does the term appropriate government means? Because this is relevant in terms of understanding the context as to on which companies the Karnataka Compulsory Gratuity Insurance Rules would be applicable. So if we look at the definition of the appropriate government, they have defined it as those establishments which are belonging to or under the central government, having branches in more than one state. Again, with this is a key relevant point. One would need to basically see whether their companies are having branches in different parts or different states within India. Factories belonging to or under the control of the central government, major port, mine, oil field, or railway company. This is the establishments who are going to be covered under the central government framework. Rest all establishments will be covered under the framework or the rules framed by respective state government. So this is how the appropriate government has been defined. Of course, this is where it becomes relevant. This is where we have received a lot of queries from the companies who are based in Karnataka or who might be having a branch office in Karnataka, might be getting registered under the shops and establishment act, and questioning whether these set of rules are applicable to us or not. If we move to the subsequent slide.
We
Yeah,
had my
yeah.
quick my two questions here. See,
Mhm.
nowadays with the with the work from home culture, also there are a lot of scenario you would see wherein people are working from home, but the companies don't have a branch. You know why? Maybe it's in sitting in Karnataka, but my company still don't have an ISIN registration in Karnataka.
Hmm.
Can an employee claim that he is following in Karnataka because
See,
he's a resident?
this is again an interesting question, and I think myself and others have deliberated a lot on this. And this is again a very gray area because since pandemic came, a lot of people were working on remote in parts wherein the companies might not be having a office, physical office per se, and they were working there. And so I'll tell you, this requirement all came into picture when we were receiving queries on the PT, professional tax, wherein companies started asking, should we be basically contributing towards the PT or not, for such remote working employees. So I would say again, not much clarity has come from the government side. There are companies who might be taking a very cautious stand, getting themselves registered wherever they are employees having. Again, administratively, it will be very difficult because if the employees are working remotely, they might be spread across odd 10, 15 states. And for companies to basically, first of all, establish themselves and create a shops and establishment registration, and then do that kind of a compliance, administratively might not be possible. I would say by and large, companies are taking a call wherein they are saying that wherever these employees are based outside that particular jurisdiction, which is not covered under the professional tax and that sort of framework, they are not doing that sort of compliance for them. Again, these questions have been raised. I think regulator is aware that such questions are coming from the authorities, but I don't think any formal circular has come into picture right now. To answer your question on gratuity for people who might be based in Karnataka, but working for an office which is based in Delhi, again it might not be applicable for them. But again, the question is, they will be entitled to gratuity. The question is whether there will be a requirement on the company to get themselves a compulsory insurance just because their employees are based in Karnataka. That is the moot question that one needs to look into. And of course, I'll ask or request other sir and Arvind to also share their comments as well.
Yeah, correct. You're right. So there is no clarity as of now on this. But the only thing here is that the most relevant thing is that uh, where is the company's operations? I
Mhm.
mean, whether and from where, whether they are having a centralized payroll processing, or they are controlling all the things centrally. Like just in the case, let us take a case of PF. Now, in the case of provident fund, what happens is that the employees might be spread across pan India, but if the company is centrally preparing their payroll and they are making compliances centrally in one PF code, which is maybe in Delhi or in Gurgaon or in Haryana, wherever it is, and they might be having multiple offices across spread across India. In those cases, also so it is a acknowledged norm that PF compliance is made only where centrally the payroll is run. So, I mean, coming from that genesis, we may say that it is not necessarily that necessary that a company should start making whether they are covered under the Karnataka Act, or in case they are having employees there in Bangalore, though the company is based out in Delhi. So, in that case, whether it is applicable or no, there is a open leeway as far as the Gratuity Act is concerned. But if you take the other laws, similar laws, in that case, wheresoever the centrally the compliances are being reported, it is taken that way.
Mhm. Yes.
So you know what, Jen, this is actually a really pertinent question for the HR professionals who are going to comply with the requirements. As far as the employees are concerned, they are entitled to gratuity, and wherever they are in India, This being a central act, this is applicable and they will get gratuity payments. But as far as the compliances are concerned, if you look at the larger labor compliances, as others and Anurag was saying, there's a gray area. And getting a license, you will start from shops and establishment. Now, shops and establishment itself, it become a challenge because you will not have an address. If you want to use the employee's home address, then it becomes gets into another area of privacy and all that stuff. So it's still a gray area. For some of the laws, it might be more impactful for the regulators, for authorities. For some of them, it may be low impact. So they don't, really get into the nitty-gritties of that. But talking only from the gratuity insurance rules, Karnataka point of view, this is something, if you have an office in, let's take two examples. One, you have an office in Karnataka and then your people are working from all the other places or some of the other states in India. Now, for that purpose, since you would not be able to register yourself under shops and establishment and other acts in other places, for all practical purposes, you will treat Karnataka as the only state in which you are present, and you will have to comply with this requirement. The other way is that you have office somewhere else and you have people working here in Karnataka. Now that is nullified by the requirement that if you have presence in more than one state, Karnataka and other states, then you don't need to, get into this compliance. So I think that's the way people can simplify this and try to answer and, get to the compliance requirements. From employee perspective, no debate. You are eligible, you will be get paid for this.
Yeah, very rightly put, Arvind. Yeah, thanks, Adarsh sir. So if we move to the subsequent slide. Okay, so just coming down to a nitty-gritties of what exactly these rules have laid down. So we have divided into three categories. One is there will be a requirement for the entities, eligible entities to get an insurance. So for all employers for whom Karnataka and appropriate government will be mandatorily required to obtain valid insurance policy, that policy can be taken from LIC or any other authorized insurance service provider. Now, relevant thing is, what are the timelines? For new employer, they have to get this within 30 days from which the rules became or came into effect. For existing establishments, the timelines that have been mentioned is 60 days. So these are the set of timelines. Of course, January 10, 2024 was when this notification came into picture. So again, 30 days and 60 days is what the new establishment and the existing establishment will have to comply with. Another thing is whenever the renewals are happening, because obviously once you take a policy, those renewals and everything have to be intimated to the authority within 15 days of such renewal. So this is another compliance requirement which will be imposed on such eligible establishments. If we move to the registration of the establishment part, the employer organization will have to file an application. There will be a prescribed format has been basically suggested in those rules that has to be filed with the officer within 30 days of receiving the insurance. So 30 days for taking the insurance. Once you receive the insurance, you will have to get yourself registered with the local authority or any other whatever the officer has been designated for this purpose. At the same time, there's a format which has been prescribed by the rules for furnishing the details of the insured employees. There's a very extensive format. And again, those reporting requirements is something that the organizations will have to comply with. The third scenario or the third aspect is around the organizations who are already having a gratuity fund. So there's an exception which has been carved out both in the central law as well as this Karnataka rules, wherein they are saying, of course, for those establishments who are already having an approved gratuity fund. And by approved gratuity fund, we mean those gratuity funds which have received the approval from the Commissioner of Income Tax under Schedule C Part 4 of the Income Tax Act. Those are treated as approved gratuity fund. So for those establishments who are already having an approved gratuity fund, or establishments who are having 500 or more employees and who has set up an approved gratuity fund, will not be required to get that insurance. Of course, once you have set up a approved gratuity fund, anyways, for basically managing the entire thing, either you manage it internally, those funding thing, or you take a again a master policy with LIC or other providers. So insurance is something that at the end of the day, every company will be taking in case they have a approved gratuity fund. Other thing is, such establishments will also be need to register. There's a separate form, and the trust needs to have five people representation, equal number, not, but or I would rather say not equal number of representation of employer and employee. A key aspect of all these approved gratuity trust, and whenever the CIT goes for approval, will be looking at that these trusts are irrevocable by nature, and it can be managed privately by the companies or by insurance company or on a joint basis.
So, Anurag, I will just like to add one thing here.
Mm.
So, just for a very simplified way to say that currently, as of now, as is, so we are having only two scenarios. One, you are having a approved gratuity trust, which is approved by CIT under Schedule 4, Part C of Income Tax Act. The other way is, the other option is that what companies usually do is they provision the actuarial valuation in the books, and they follow pay as you go approach. So there is no fund which is committed to gratuity. It is just a provision. And whensoever employees leave, the eligible employees leave the organization, from the running cash flow, employers usually pay. So it is known as pay as you go approach. But now with this change amendment, what is proposed here is that even the provision is required to be insured. Right. So that is the only difference here. That the insurance, they say that whatsoever provision you are going to make, that has to be backed by a insurance. So if you are having a, let us say, actuarial valuation of, let us say, 100 crore rupees, so this 100 crore rupees, though there is no asset, but this is required. This is not backed by any asset. This is just an actuarial valuation. But corporates need to take a similar insurance policy for this 100 crore rupees. So that is the only difference between the differentiator between what is going to happen in future.
I think that is the I think the logic that the government want, or the respective state government would like to do. And this is a very good point that you have highlighted, sir, because right now many companies might just be creating a provision which is not backed by
Any asset.
any asset. So the problem here is, if the company goes belly up, then in such a case, how will the people who are entitled for gratuity gonna be paid?
Yeah,
So I think
a live example. There is a live example also.
Yeah.
Like you see a live example of a lot of airlines which have gone defunct. So overnight, the airlines they don't have any money to pay the basic salaries. Also, they are unable to pay. So in case what happens, this is a legitimate right of the employees. So since there is no set backing on that, so employees when they are not getting the salary, how they will be able to get the gratuity? So that's the only concept behind that. That all the provisions should be insured. But the bigger question here is, see, I was checking with though I am, not sure about it, because there are varied type of, solutions coming from the insurer sides also. Some say that there is no insurance product which will be, no insurance will be able to, give this such a policy, or they're still working on the type of policy framework with the approval of IRDA. So I think so. The things are still to materialize. They are still in a very conceptualization stage only.
Yeah.
So that's just the additional input from our side.
No, right. But then the logic comes, if this is something which is not relevant to a particular state, but rather this is something that has to be or needs to be done by at a state level. Then the question that comes to one's mind is, the act came somewhere in 1972. We are sitting in 2024. And right now, only two states, Andhra Pradesh and Karnataka, have come out with these set of rules. For other states, so the question which as a layman could come to one's mind is, why are other states not moving forward? Why are they not putting such set of rules? I mean, if we look at it, it's a 1 or 2 pager rule that just needs to be notified. This will ensure that employees are not suffering any hardship in case an organization goes insolvent. And again, the insolvency of a company is not state specific. It is not as if Karnataka companies are facing a huge number of companies who are going defunct or winding up there because of or becoming a sick company. But this is happening across India. So why, the question that comes logically is, why are other states not doing it?
Correct. So, one of thing which comes to my mind is that, see, that we couldn't find any written material on this, right? Why AP and Karnataka, they have taken, a front foot for implementing this gratuity. But one of the major reason being that, see, these two states are manufacturing and IT hub, and they are having very larger population of employees. Young employees also coming from the other states as well as their own state itself. And for for the financial benefits and to uphold the rights of the employees of their state, they have taken the lead. That could be the only reason to our understanding.
Yeah, just to add to what others is saying, there also it's also triggered by some of the recent incidents which happened where some of the big IT companies, and I don't want to take names, but they defaulted on gratuity payment, including many other payments and benefits which are due for the employees. And that's when I think the government thought that this is one of the opportunities which they have. This is a provision which is provided in the Central Act. Let's make use of it and have a simple rule being promulgated and passed, which can actually require these companies to back up their, actuaries, what they are actually calculating with an insurance, where even if they are defunct or they don't have the capability to pay, there would be a third party who can pay for it, and there would not be many disgruntled employees who will come to their doors knocking and asking for those payments. So I think that's a way which the labor authorities decided that let's make use of the law, which is already present, as Anurag was saying, for so many years. Let's make use of that right now and make them accountable for what they are actually, claiming that that's a benefit, or which is actually a statutory benefit. So that could be one of the reasons, but that's definitely not the reason for other states not to act on it for so many years.
Yeah.
Mm.
In fact,
And
this
the
is
part
something that the organizations will have, or other state governments will have to do, because companies will not push the state government to go in for insurance, because right now they're just simply creating a provision in their books. Employees might not be pushing over because they might not even be aware. They just know that they are entitled to gratuity, but they don't know how the funding is going to come into picture. For them, it's the ultimate payment. So
correct.
somewhere down the line, the catalyst has to come from the government side only, in terms of coming out with these set of rules.
And right, and the point of question here is that see, this will come with a cost, and it will be hefty cost. And I think so probably whenever the insurers come with the product, they will definitely be analyzing. They will be doing their own due diligence, and the rate of insurance policy will vary from industry to industry. The way I had shared, know that for airlines industry is one of which is very vulnerable. So for them, there will be a different rate of interest. For the other type of industries, be it manufacturing or so that type of due diligence, this insurance companies will be doing either through their actuaries or through their resources, and then there will be benchmarking the rates applicable. It will, I think so. It won't be a uniform rate. It will depend upon the specific industry. Yeah, so that will come with a cost, definitely.
Yeah. Now, speaking of cost, I'll quickly move on to the new labor codes and how it will be impacting on gratuity, because that is where your cost consideration will again come into picture. So quickly running on the new labor codes and how it will be impacting on gratuity. See, if you look at new labor codes, what the government has done is they have subsumed 29 existing central labor law legislation. It's like it's going to be a big moment for the company and their employees. Of course, the all the four labor codes have received a presidential assent. It is effectively a legislation The only thing which remains to be done is to for the government to notify the date when all these codes will be coming into picture. Just for our largest set of audience, there are a couple of sections of Social Security Code, in fact, which has already came into picture, particularly to do with the Aadhaar linking, particularly to do with the higher pension scheme, wherein the government activated certain sections of the Social Security Code and have put those particular sections into effect. So people might be thinking that, oh, this labor code came in 2020, nothing is happening, so it will not come. That is not the right sort of like I would say conjecture. Rather, this is something that will come, of course, because labor legislations are a concurrent topic. There has to be a central and state interplay which needs to come into picture, and the states also have to come out with their own set of rules. Majority of the states have drafted their rules, and there are few states who will be finalizing it. Of course, with the upcoming elections, and how the turnout will or what will be the outcome. We are hoping that probably this year only the Social Security Code might come into effect. So we'll watch out for this space, and of course, Jayant is there, so we might be organizing a full-blown session on the labor codes soon. If we talk about how it will be impacting the change in the gratuity computation, as we were telling earlier, every labor legislation has a different definition and interpretation of the term wages. Of course, gratuity, the wages was defined as basic salary plus DA. But what the Social Security codes have done is they've come out with the uniform definition of wages, which will be basically determining your entitlement towards PF, leaves, overtime, and many other kind of a benefits. So there will be a single uniform definition of wages, which would be applicable. And that's a far wider definition as compared to what we have right now. So one impact that we are going to be seeing is that because of that wider definition of wages, the gratuity outflow might increase, because the methodology that they prescribed in the Social Security Code remains the same. It is 15 days salary for completed year of service, but 15 days salary. Salary means wages. Wages is your last earn, and there is an expanded definition of wages. So what we are seeing is there can be a good amount of impact, because the Code on Social Security hasn't laid down any grandfathering clause. So let's suppose the Social Security Code comes into picture. Let's suppose in June 2024, July 2024, somebody resigns. They are entitled to gratuity. We do the calculation. The person has might have rendered a service period of 20 years or 30 years. Then the gratuity outflow would be basically calculated on those definition of wages only. Right now, government has not done anything on whether what will be the cutoff date or something around it. We expect that there might be some clarity. Of course, industry has given a lot of representation. Industry are worried that it might have a good cost impact on their balance sheet. So it remains to be seen how it goes. But this is how presently the law is worded and how it might be impacting you as an organization. If we talk about another aspect is another around the fixed term employees. Now, fixed term employee, they have provided a very specific definition of a fixed term employee. These are people who are under normal employer-employee arrangement, but with a set tenure. So for those category of employees, also the gratuity will be paid, albeit on a proportionate basis. So I'll give you an example. Let's suppose we have expats coming into India or typically a fixed term tenure. So let's suppose if they come to India for a period of 3 years, right now they are not eligible to get gratuity, because of course they would be going back after completion of 3 years. But once the Social Security Code comes into picture, then in such a case, they would be entitled to a gratuity on a pro rata basis. So this is another thing that companies need to factor into. So right now, I think I remember a couple of years back, a lot of companies were doing an impact study as to how the labor codes would be impacting them. Of course, since it has been postponed, so right now companies are just doing a wait and watch. What we are suggesting them, or what we are telling them is keep a keen eye on this particular development. As and when it comes, one would need to do an impact analysis as to how it will be impacting the gratuity policies, how it will be impacting the gratuity payout, as well as your actuarial valuations as well.
So,
Yeah.
just to add one thing, I think we've already done one webinar on code on wages. We'll be doing more on the, on the new labor codes. If anybody wants to refer to the code on wages, because some of these, aspects have also been covered. And as Anurag very rightly said, I think it's a matter of time. The election are underway right now. The new government will get formed in the month of July and in the month of June. And I think immediately the government's agenda, the labor codes are something which is under in the agenda of government. So one has to, keep, one has to understand what's there in the labor codes and factor them in. Even if you are not completely, implementing the labor codes right now, because I'm sure, we've been hearing about labor codes for the last 4 years almost. So with that uncertainty, but keep that in mind. Keep those factor them in, be aware, because I think it's a matter of time when these codes will be implemented.
Yeah.
Arvind, one specific questions on this, from you. One is how, from a practical aspect, because you see both the sides, right? Now, how you see companies getting prepared for, for the labor codes, and what kind of queries, issues which you are, being a general counsel, you are, you're receiving from your HR finance teams on these changes which have been brought in?
Yeah, thanks for that, Jen, because we have been bombarded with many of those questions, especially around 2023. There was a lot of talk around this. There was also some statement from the State Minister of Labour Department that they're going to work out on the rules and then going to notify the act soon, but nothing happened. And then 2024 came in and everybody is focused on election right now. So most of the things were around, either the definition of wages, or settlement period, FNF settlement period, gratuity, what kind of cost this is going to increase. I think these were some of the questions related to the law, and some of the questions around how to, get these things put in the systems, which HRIS systems, which companies are following, and how would they enable something like, say, 2 days, 2 working days, full and final settlement, those kind of things, which the systems are not enabled to do right now. So many of these kind of questions were there. The tax implications on the employer, whether that's going to increase or decrease because of the PF contributions, etc., and the basis for the calculation. And many of us, what we did is that we took the opinion from both sides, one from, say, the big fours, which could be the tax consultants, and from the law firms, and all of them were in the gray area. They said that some of these things we can talk about right now, but for some of these things we have to wait for the rules to be out. And since the rules are not yet notified, it's not out, there was no definite answer from any of these external consultants. But yes, some of the questions have settled down for the time being. I can say that for last 6-8 months, I am not receiving much questions on labor codes. I think this is now settled down, and people are thinking that it might take its own sweet time to be out. But as you rightly said, there is a discussion around the corners that once the elections are over, this might be one of the top priorities for the new government.
Yeah. Okay.
Thanks, Arvind.
So I'm aware and conscious of the time. So I'll quickly go through a couple of slides, and primarily I'll focus on now the tax impact. See the tax impact on the employee side, because that is where employees might be uh, uh, keen to understand how when gratuity is paid by the organization, how it will be impacting them in filing their return in their income tax computation. So if you look at provisions of the Income Tax Act, they say that yes, gratuity forms part of the salary. It will be chargeable to tax under the head salaries only. But then there are exemptions under Section 10, which have been carved out. And there are two buckets I will consider. Of course, gratuity payment to government employees is exempt. But if I see it more so from the private sector perspective, so if we look at the first bucket, it says the gratuity which is received by an employee, where employee is covered under the Payment of Gratuity Act. Then in such a case, the least of the following is exempt from tax, which is this 15 days salary, as well as there's a statutory limit of 20 lakhs and gratuity which is actually received. So whatever is the least of the amount, that will be exempt, and the delta figure will be treated as a taxable income. Now there's a second bucket, and many times I have been asked this question as to what this second bucket is all about. I'll tell you very quickly. But if we look at the formula, apparently it looks exactly the same. They're using 15 days salary. It talks about in a half month salary only, and then there's INR 20 lakhs. Everything looks the same, but again we have to look at a fine print. First of all, what it says in the second bucket. So in case of gratuity received by an employee where the employer is not covered under the Payment of the Gratuity Act, so these are any other, or you can say residuary cases. Now what are those cases? Is basically those companies who are not limiting the payment of gratuity to a statutory limit of 20 lakhs. So those are those companies who are making payment of gratuity not under the PJ Act, but rather providing a beneficial terms of gratuity. So if we look at a very, very fine print and a strict interpretation, wherever companies are not limiting their gratuity payment to 20 lakhs, then for them, while they are doing the computation, they will have to factor this particular subsection when they are calculating the calculation amount. Now, one can say there's hardly a difference, be it this subsection 2 or subsection 3. We can do with the first one only. The answer is no, because if we closely look, they are using the word half month salary for every completed year of service, basis average salary for the last 10 months. So in the first bucket, the salary will be your last drawn basis. In the second bucket, the salary will be based on your average salary. Okay. So obviously your salary amount, if we work it out on an average basis, may decrease to some extent because you are averaging it out. The second important factor is they're using, again, in the former bucket, the formula is 15 by 26. Here they are using half month, so it will be 1 by 2 or 15 by 30. That will be there. Another thing is the completed year of service in the first bucket is, so let's suppose if a person has rendered a service of 6 years, 7 months, in the first bucket, it will be construed at 7 years. In the second bucket, it will be construed as only 6 years because a fraction of that thing is something which will be not considered. Bottom line is, it might so happen that in the second bucket, the amount of exemption that you get might not be that much. Okay. As a result of which, if you still go with the first bucket, then you will be basically paying less taxes or deducting less taxes as compared to the first bucket, or rather second bucket. So this is where the key difference is. Of course, depending upon the facts and circumstances of the situation, one would need to look at those numbers before we finally conclude. But this is purely based on our practical experience that we have seen that companies will have to follow this particular or the second bucket wherever they are not limiting the payment of gratuity to the statutory limit. If we move to the tax impact on employers, again, there's a lot of debate and a lot of queries and that I receive from companies wherein they say, I have can I make a direct payment to LIC, and I don't want to create a gratuity trust. What if I just create a provision? See, it all depends on how the income tax has carved out different provisions. If we look at the interplay between section 36(1)(5), section 40(a)(4), and section 43(b), they say wherever companies are making a contribution towards approved gratuity fund, again, approved gratuity fund means those fund which has received the approval from CIT, then such contributions are allowed as a deduction, provided such deduction has been made before the due date of the filing the return of the income, and employer has made necessary arrangements for deduction of TDS. So this is the first thing, that wherever I'm making a contribution towards approved gratuity fund, in plain simple, it will be allowed as a deduction. Second is for companies who are just creating a provision. If we look at the provisions of section 40(a)(7) of the Income Tax Act, such provision is not allowed. as a deduction unless until those provision has been created to make a contribution to a approved gratuity fund or for the purpose of making a gratuity that might have become payable. This is the second thing. The third thing is 40A7 basically says, I think there's a typo here. It is basically 40A9, which says that any sum which is paid by the employer or organization towards setting up or formation or as contribution to any fund other than an approved gratuity fund is not allowed as a deduction. So plain and simple, wherever companies might be making a contribution towards an unapproved gratuity fund, those will not be allowed as a deduction. Now, this is the entire framework of the Income Tax Act, but again, there's a catch to it because practically what happens is when companies submit their application with the CIT, sometimes it may take 3 years, sometimes it may take 4 years. I've practically seen companies who have submitted this application, 10 years have gone by and they are still to get an approval. So now the question comes up, when I have a gratuity fund in place for which I have submitted an application with the CIT. CIT has not yet approved or provided a approval to that. Can I, whenever and I'm governing and I'm complying with whatever provisions have been laid down under the Income Tax Act as well as the related rules, will I be allowed to claim it this contribution amount as a deduction or not? Answer is yes, based on a number of jurisprudence wherein the ruling authorities have told that it is the onus of the CIT to basically grant the approval. Once the company has submitted the application, they are duly complying with whatever provisions have been mentioned, then such contribution can be allowed as a deduction. Again, an important factor is whenever the CIT gives the approval, it is usually on a retrospective basis. So this is one key aspect that many companies need to be aware about.
And companies have leeway also to part fund the provision. So in that,
Yeah.
let us say someone is having 100 crore rupees of a provision. The way Anurag was telling, it is not necessarily that for the corporates to fund 100% of that money under the gratuity trust. They can part fund it also. So in that case, there will be a hybrid model wherein company will be entitled to income tax deduction for whatsoever amount they are funding to the trust. For remaining amount, it will be provision in the books only. We are just discussing the as is position.
Yeah, yeah.
So I mean, there is a question coming up, very relevant question also. I'll just take 1 minute on that also. So there was a question that they are not limiting the gratuity to the maximum threshold, that is 20 lakh rupees. So they are paying over and above. So if in case they are paying over and above, then this will not be covered under gratuity. So it will be it is an additional payment, which is not covered under the Gratuity Act. So that is an ex gratia. It will be treated as an ex gratia payment to the employee, and it will be taxable in the hand of employees.
See, the only thing I would add here, other sir, is if you are making a ex gratia payment, then whether exemption under Section 10(10)(3) would be applicable or not. My answer is rather than terming it as ex gratia payment, you term it as a gratuity only because ultimately that is how you are calculating it. And anyways, you are a establishment which is covered under the Payment of Gratuity Act. The only thing you need to put in your policy is that the company is providing a better terms of gratuity instead of what has been statutely mentioned under the Payment of Gratuity Act. So that ways, when you are doing that calculation, you can do a calculation and provide an exemption of that gratuity amount.
Yeah, but this needs to be applied to CIT.
Yeah. Okay, so quick key takeaways because I know many questions are coming up. So we will just to conclude on our key takeaways with this presentation is first and foremost, evaluate if your organizations fall under the mandatory insurance regulations. Keep in mind what are the Karnataka compulsory insurance gratuity rules, whether you are first and foremost eligible or basically whether that particular rules are applicable to you or not. The second important thing is compare the options and the options available with you as Alt A, create just a provision in the books. Alt C is direct payment to a group gratuity scheme. Again, this is a very litigious topic. Third is establishment of a gratuity trust. Yes, it provides a lot of benefits, but at the same time, it is not very easy to wind up the gratuity trust. It can only be done whenever there is amalgamation or merger or some kind of a scheme of arrangement that has been come. So These are the three alternatives available with an organization. Once the labor codes are announced, just see and analyze what impact it would be having on your gratuity payouts. Of course, how you structure your wages, how you structure your policy is something that would need to be considered. And last but not the least, determining whether the organization should cap the gratuity payment at the legal limit or offer more generous gratuity terms. Again, this is a policy level decision making that an organization has to do. Many organizations don't limit it. Many organizations limit it to the statutory limit. Of course, for serving people who are rendering 15 to 20 years of service, for them, a benefit is that it should not be limited to a statutory limit only. So these are the different aspects that one needs to consider. So now we can move to the interesting part around what questions we have received. We have just formulated it here on tech only. These are some of the questions, and I think yeah, Jayant, you can take it up.
Yeah. So this is for everyone. We have already at 4:36. We've crossed our time limit, and we still have this FAQs to be covered. I hope you're okay to continue because these are some of the interesting queries which we have received from everyone. Great. Okay. So if I can have some more thumbs up, I think that gives me more confidence that we can continue with this. Awesome. Great. Thank you. Great. So, and my request to everyone, if you still have any questions, please, please keep asking. We'll try to take this. And and a couple of the last couple, few slides where we spoke about the tax implications on employee and employer. My request is you should keep, we will try and have those particular portions separately uploaded on our YouTube channel as well. You can keep those links because it could be useful when you are, having the discussion with your employees, or maybe if you are an HR person having this discussion with your tax and finance functions, or maybe business functions also, management also, because this is crucial. Because when you are to take provision, how it is going to impact your books, how it's going to impact your, what kind of tax implication will come onto you. These are important decisions, discussion points for taking the decisions. I think it can be bookmarked. Quickly coming on to, I think, Anurag, Adasar, and Arvind, I'm going to be making this open to all of you. What is the purpose of to implement mandatory gratuity insurance for these states? Is it from the perspective of social securities of the employee? I think partly Adasha has already covered into this part, and I think I have also follow-up questions. Are we expecting more states to follow follow this?
Yes, of course they will be. There's no doubt in that. Of course they will be.
On a lighter way, Jayant, if we answer these questions, will we get a coffee hamper, something like that? Okay, let's.
So ultimately, this the states, they have to follow. It's as simple as this. Everyone has to come up with their own gratuity laws, and this has to be implemented in totality in India.
Okay, all the compulsory insurance rules applicable for entities with operations in more than one state. I think this was also part. This
was already answered when we started the conversation on this.
Right.
We can move to the next one.
Yeah. Apart from Karnataka, which state has such insurance requirement?
Yeah, this is answered too.
Right. If an employer has offices in all states, what this rules will be, has been enforced. What should be the process of to procure the insurance? I think this also got covered. What kind of a liability does this insurance covers? Does it trigger upon claims from employees or any other event? I think this is an interesting point.
Yeah, Adarsh, I think you can take it up based on your practical experience.
So thing is that this is employer which pays to the employee, and this has to be paid within 30 days. Otherwise, there are consequences on that. So this continues under the new legislation also. So and doesn't trigger anything for employees too. This is an auto process where employer has to pay to the employee within 30 days from separation or from retirement or whatsoever the case is.
I think, Jen, if the question is just to add to what others is saying, if the question is around the insurance cover which we need to maintain from time to time, I think this has to be for the eligible employees. So if they have become eligible according to the calculation of that 5 years of continuous service, then that employee's liability to pay the gratuity, the amount equivalent to that will have to be part of the coverage. So we have to keep updating the coverage. Sorry, sir. Go ahead.
Yeah, that's right. That's right. So we are talking about the provision. So we are talking about two things here. One is that what is the liability that insurance covers? The insurance covers all the provisions, actual provisions, what company is making. So that is covered. Second part is that whether employees trigger anything. So the answer is no. This is an auto process where employer automatically has to pay this money.
Okay. I think, you partly already answered the next question, but anything if you want to add?
Anurag, you want to add something?
No. Yeah.
Okay. Yeah. Let's move on. What are the new labor codes? Yeah. Okay.
Again, this is a $1 million kind of a question. When are they going to be notified? As a consultant, I would be very keen if they are notified because it brings a lot of challenges for the companies. But at the same time, it is something that the government is saying will be a game changer because not only will they be covering employees in the traditional sense, but these the codes will be covering gig workers as well as platform workers as well, of which we have been hearing a lot about in the media as to how they should be covered under the various social security benefits. So again, the expectation is, and I was reading somewhere that as a part of their 100-day plan, and again assuming if the NDA government comes into picture, this is a part of their 100-day plan wherein they will come out with the or notify the labor codes. So again, and we'll just have to wait and watch. But the second part of the question is interesting because we quite receive this kind of queries from companies wherein they are of the understanding. And again, depending on the various media articles which are floating, which says that just keep your basic at 50% and then you're totally covered under the labor codes. That is a misnomer, I would say, because if you keep your basic at 50%, many companies have another component called special allowance, for which there is no exclusion under the wages definition under the new labor codes, in which case effectively your wages might be at a level of 60 to 70% of your CTC, and it is on this wages that your retirement benefits or benefits like provident fund, ESI, overtime, and other sort of payments would be covered. So I would say don't take it as a sort of like a plain sort of like formula by saying okay 50% of basic and I'm thoroughly covered. That is not the correct way. There has to be a deeper analysis as to what components you are providing, what are components which are included, what are excluded, and there is a conditional exclusion clause as well. So a deeper analysis needs to be done for such kind of things.
Arvind, from a labor code standpoint, would you want to add, share some of your experiences as to how you're seeing organizations started, working on them, and maybe anything you want to share?
See, again, as Arvind highlighted, I think 8-9 months back, we were doing a lot of studies for companies wherein we were providing labor code impact study. But now companies just want to do a wait and watch. Obviously, they don't want to roll out something which might not actually fructify at the end of the day. So, but at that point of time, when we were doing the study, the first thing that we used to do was first and foremost assess what are the kind of components or benefits that the companies are providing. And we have to keep in mind that the wages which have been defined under the labor codes cover not only the payments which are made on a monetary basis, but also certain benefits which are provided on a non-monetary basis. And these is what we in tax terminology call perks or perquisites. So this is another area that we used sort of kind of a mapping thing we used to do in terms of mapping what kind of a benefits, monetary or non-monetary, or wages or salaries being provided by an organization, what will be covered, what will not be covered. And based upon that, what is the situation in a as a scenario, and what will be the situation if the labor codes come into picture, what will be the kind of outflow from the PF side, leave encashment side, overtime, gratuity. So all this is something that we used to analyze. At the same time, we also were looking at what is the existing policy of an organization and how those policies and procedure need to be realigned with the new codes. Very quick example, because the full and final settlement that they are saying is has to be done within a period of 2 days, and there's a lot of furor in media wherein they were saying how can one do a sort of like settlement in 2 days. Again, that's a kind of a misconception that is there. You have to look at the fine print of the law and see when such kind of timelines would be applicable, or on what components such a timeline would be applicable. So that is how we were doing it. Of course, a lot of states have also drafted out their rules as well. So when we would be doing, or when we were doing that exercise, we were also having a look at those respective state rules as well, as to how those policies and procedure have to be aligned with the respective state rules.
Sure. So, I think this also, the question number 7 was also partly discussed, but
Yeah.
And we can just move next. Arvind, this is the next question, which I think this is something which you brought in during the discussion. Can a continuity benefit be provided to an employee transferring from one group entity to another? I think this is just part of the question, but it has a larger impact, because we are seeing M&As, we are seeing today scenarios wherein employee is maybe transferred to some other entity. So I mean, I want to bring you into discussion on this question. And
Yes, Jen, then interest of time, I'll try to keep it short. So I think we can divide that into two buckets. At least one is between the related entities, where you have the affiliate format, and you want to transfer employee from one affiliate to another, and you do it for business purposes. The another could be where you have M&A with unrelated party, or you could be or as acting as employer on record. You are. So that's something which is quite famous, and we do it quite often for our clients. Now, in those scenarios, this is actually an arrangement which is entered in the contract, which we signed with the employees, where it is clearly called out that they are actually going to be transferred to another entity. And then when this another entity is going to take them up on their employment, they are also going to get the continuity of service benefit. And that's how it is done. As far as the related entities are concerned, generally they keep it under their policies, their employee policies, their service conditions, however they want to call it. And that there they have clearly called it out that if you are transferred from one entity to another, this is what you get. And as Anurag was saying, some of the courts have also ruled this in past, that you have to provide that benefit, not just in India, but even if when you are transferring these employees to your overseas entity and then they come back and all that. So I think this is how it is generally dealt in the practical scenario. The Act doesn't cover that, as we stated in the beginning, but this is how the courts have treated it, and this is how the employers do it for all the practical reasons.
Yeah. In fact, Arvind and Jayant, this year only Bombay High Court had adjudicated one ruling wherein an employee was posted, or rather I would say transferred to a entity outside India. Again, both the entities in India and outside were falling under the same management, and that's how the court said that if both the entities are falling under the same management, then in such a case the company is bound to provide that continuity advantage to employee. At the same time, because first he was in company A in India and then company B in outside India, and then left the employment. So the question came, when the company needs to pay gratuity, should it be on the last drawn salary in India or last drawn salary outside India. That is another key point, because whenever a person is moved outside India, their salary structure also undergoes change depending upon the requirements in the host location. So that is another key factor to understand what will be the basic salary. If I say my basic salary in India was X, obviously when I move outside India, let's suppose if I move to a European country, obviously it will be X plus so and so amount. So it will again have an incremental outflow for the companies based upon the way court adjudicated, or rather said that it has to be on the last drawn basic outside India only. So and one thing is, we have to be mindful that no contract can be structured in a way wherein an employee will be giving up his or her right for gratuity, because any contract which company enters into with an employee via which employee forgoes their right will be basically you opting out of the provisions of the Gratuity Act, which will be void from day one. So of course, no structuring or contract can be done. Uh, at the same time, the companies, whenever they are issuing the letter to an employee for secondment, they have to keep these important aspects in mind as well, around the gratuity leave encashment as to how these employees will be entitled to.
Then
So
thanks, Anurag.
quick addition to what Anurag is saying, whenever we have doubt, we have to go back to the purpose of the enactment. And the purpose of this enactment here is a kind of gift which you give for the loyalty which an employee has shown to you as the employer, and you cannot circumvent that legal requirement by having different entity formats, by transferring employees from one to another and all that stuff. So if the provision is very clear that this is something which you have to provide, the purpose is aligned with what you need to do, then you do not have an opportunity to do these things through, creating something by which you can circumvent or avoid the legal requirements.
Right. I think this is, thank you so much, in fact, for elaboration. I think for elaborating this point, because I think there were quite a few questions on this. I think, Megha, I'm seeing your scenario, which we were talking, is exactly what Anurag explained. Hope this clarifies. Uh, I think next we have already touched upon anything else you want to add on to the to point number 9, Anurag?
No, nothing.
Okay. What formalities are needed to provide a better terms of gratuity? Others,
Uh,
you.
I have just one point to add here. In order to provide a better terms of gratuity, and again taking a cue from that ruling, 2024 High Court ruling, wherein just by confirming it on email wouldn't suffice, wherein employer organization says, okay, you will be entitled to so and so. Rather, it should be a more a kind of a part of the policy as well as a part of that contract. Then only the courts will recognize it as a company providing a better terms of gratuity. So this is one important aspect of the nuance that was highlighted in that particular ruling.
Yeah, mere confirmation won't do.
Yeah.
And there is one last question. I think we have touched on it, but again, this is coming in. Can a fixed term employee whose agreement has been renewed yearly without break by the employer be entitled to gratuity? Your contractual employees, your consultants also get covered in that.
See, again, this is a very good question asked, because many companies uh, do structure such kind of things. I would say exercise such kind of a structuring with a lot of caution, because again, if your prime intention is just to basically obviate your liability for gratuity, then the authorities will smell this. And of course, uh, because the fixed term employee concept means that you are for associated with the company for a fixed term. Now, if you're doing that just to basically break their continuity and sort of like eliminate your responsibility or liability for gratuity, this is something that the courts will not accept, and it is something that will not fall in organization's favor.
And Anurag, anyway, this will be history after the labor codes are notified
Absolutely,
and
absolutely,
applicable.
absolutely.
Great. I think we are good for now. Thank you so much, Arvind, Adarsh sir, and Rag. It was. I just realized, three of your names start with A. We have three S's. Okay. Thank you so much, for this lovely session. I think this was quite interesting, and in between, I think this, discussion went very deeper, and I'm urging everyone, we will be sure, we'll be also publishing short videos in the book. You should bookmark it, because you would need to go back to those queries which come from the employees and from your finance teams also. And in case you still have a few, any further queries, feel free to get in touch with us. You have you have our email IDs, mobile numbers, and you can always reach out to us. And we hope this session was helpful, and we will also be uploading the session recording on our YouTube channel. Trishul has and Akshit has already shared the links to those YouTube channel. You can subscribe, and feel free to refer back to any time. Thank you. Thank you,
Thanks,
everyone.
Jan.
Thanks.